Good morning, friends. While dealing with section 139 of the CPC, we'll be telling you regarding the affidavit. So all of you know what is affidavit. Affidavit is nothing but a sworn statement to the facts known by you or to the facts exclusively within the knowledge of person and attested by the notary public or some other advocate. It is called affidavit. So a doubt has come to some students whether affidavit is evidence or not. If you go to section 3 of the Evidence Act, what is evidence? Evidence means all statements or all documents which the court permits to be produced before it by the witnesses. That means whenever you go and depose evidence in the court, then only it's called evidence. That's why list of charge sheet we call as lists of witnesses, but in the court we call as prosecution witnesses or defense witnesses. So please remember, evidence is that which is recorded before the court. But what is the affidavit? Affidavit will also become evidence if it is subject for cross-examination. Merely affidavit is not evidence. Affidavit is only a statement. Statement relate to the facts known to the person. Statements which are relating to facts which are exclusively within the knowledge of that person. So therefore, affidavit is not evidence. However, in a case where the deponent is available for the cross-examination and opportunity is given to the other side to cross-examine him, then it can be relied upon as evidence. Right? So, right of cross-examination is an integral part of natural justice, definitely. Even though we tell you regarding 144, 145 Evidence Act, there is a procedure for cross-examination, but it is a part of natural justice, of course, though not provided under the legal statutes. Right, of course, here in this case, you can read the case as AAYUBKHAN, Noor Khan versus State of Maharashtra 2013. So you can see it in 2013 volume number 4 SCC 465. So here this Noor Khan was given a caste certificate on 19/10/89 that he belongs to some Bill Tadvi, that is ST. He was appointed as a senior clerk in the Municipal Corporation of Aurangabad. Alright, somebody who is not satisfied with the caste certificate or who says that the caste certificate is bogus one, then definitely he has filed a case against this Noor Khan. Right. So actually, when he leveled allegations, there is a committee that is called scrutiny committee. They are verified and they stated that he belongs to ST, that is Bill Tadvi caste only. But after 9 years, once again, he has filed a case stating that this man, Noor Khan, does not actually belong to ST. And he is a professional Muslim. He is a Muslim and he cannot be a scheduled tribe person. In this connection, the other side, who has filed a case against the writ petitioner, he has filed an affidavit in the court. So when the person was called for cross-examination, he did not come. So the High Court said it cannot be valid as evidence. It is only affidavit. Of course, we can take it to consideration or not. It is so. When you give an affidavit, you must be ready for cross-examination also. Then only it becomes evidence. So normally the person was under the impression that affidavit is sufficient to be taken as evidence. But the court has clearly stated that it is not evidence. That too, High Court observed that there are certain previous judgments which say that in service matters, this public interest litigation or writ petitions cannot be allowed. Because service matters, they will be dealt with CCA, Code of Conduct and Appeal Rules. They are separate entity. So you cannot file a petition. So this is the thing. So please remember, an affidavit cannot be evidence unless subjected for cross-examination. Good judgment. Normally, so many people are under the impression that affidavit is equal to evidence. Evidence will become evidence only when the person who has filed the affidavit is examined cross-examination, and of course, later re-examination also can be done. So In other words, already as I said, it is equal to examination in chief, right? Please, if you remember this much, this is sufficient. Thank you.